Double D and I were just talking the other day, and we were talking about how not everybody knows their rights and what to do at a traffic stop. And we thought it would be very powerful and a very good thing for the community to explain that. Now, from two perspectives. I'm an attorney and also I ride, and I'm a biker as well, and I've been profiled many times. Double D, of course, is a spokesman for the motorcycle community, and he has a perspective. So even when we were running through it, his perspective was vital to this presentation because we see things from a different place and from a different world. And there's a lot of things that people just simply don't understand. So what we want to do is we want to go through the powers of the police, what they legally can do under the Constitution, and we're dealing with United States Supreme Court cases that affect the entire nation. Now, some states give you more protections. Washington gives you more protections. In some ways, Nevada gives you more protections. But we are talking about the law in all 50 states and what the law is in all 50 states. So this can be anywhere that you're riding in the United States of America. This is the way it is. You might have more protections depending where you are. Now, first of all, 100% police have the right to control a traffic stop. Completely control a traffic stop. And if you try to overpower them or to do something to take control away from them, they are allowed to lay hands on you and make sure that does not happen. And that's done for their safety. So when you get pulled over, whether or not it's legitimate or not, you have to allow the police to control that traffic stop. When they control that traffic stop, you have to give them your license, your registration, and your insurance. They are then allowed, for the driver that is, they are then allowed to take that and run it for wants and warrants in their computer system, write their citation, and then either issue the citation or warning or give your stuff back and go. That is an ordinary and routine traffic stop in its most basic form. After that, or during that, they have special powers for their safety. And that's under Pennsylvania v. Mims. That's the court case. And so they are allowed to do certain things for their safety. They don't have to, but they can. For instance, they can ask that everybody get off the vehicle or out of the vehicle and place them somewhere, position them somewhere for their safety. They're allowed to do that, and you must comply. If they tell you to get out of the car for their safety, you must comply because their safety is part of the mission of the traffic stop. Additionally, if they have reasonable suspicion that you are both armed and dangerous. Now, reasonable suspicion is not much. If they've got any reason to believe that you are both armed and dangerous, if that happens, then they can pat you down. And they can pat down anybody in the car that they believe is armed or dangerous.
Yeah, that doesn't mean a complete search. That means a pat down on the surface for weapons, correct?
Yes, yes. It's a pat down for their safety to see if there is any weapons, and then if they feel anything that they could reasonably believe is a weapon, they can then investigate further. They can go into your pockets. They can do those types of things. Now, this is why it's very, very important that you are respectful, right? You have to be respectful, because if you get aggressive and if you do something that makes you look dangerous, even when Double D and I were talking about this yesterday, he was being calm, but sometimes he can be intimidating. He's a big guy, he's a biker, and I was pointing out to him that some of his body language was indicative of someone who might be dangerous, and I actually pointed it out. Shifting weight, when he did that before, where he's shifting weight, arms folded, a scowl, all these things. If you look mean, then you are armed, you can be dangerous. And then if they have reasonable suspicion that you're armed, they can then pat you down. And so it's very important that you're polite. Now, that is what an officer can do under the Constitution with a traffic stop, unless they have reasonable suspicion of something else. If you've got a scale and a police scanner, in your car or on your bike, they get to investigate further because that's reasonable suspicion of other things, right? Or baggies with little powder in it, whatever, right? But that encompasses what a police officer is allowed to do, unless...
How polite should you be?
Well, just a second. We'll get that. Just a second. Unless you give consent. Give consent. Now, how polite should you be? Okay.
You should be polite. You should say, sir, I do not consent. Sir, I do not answer questions. But nothing beyond that. You shouldn't be overly friendly, overly congenial, because that can be interpreted as you voluntarily giving consent to extend the length of the traffic stop.
Who here has a buddy that's a little chatty, right, that likes to talk? Who here has a buddy that likes to pop off to police officers because they're mad that they're getting profiled, and so they like to pop off the police officers? Guess what? That guy in your group that just popped off the police officers, he just consented to extend the stop and have you guys there a much longer period of time. That guy that gets chatty, who wants to talk about whatever, the weather, whatever it is, right?
His motorcycle, anything.
Sure, right? If the cop just tries to make small talk, if you participate in that small talk, or especially if you instigate that small talk, you have just consented to them extending the stop. All these cases in the courts, all of them, deal with areas to where it's a question based on what you say or what you do of whether or not you consented for them to search longer or hold you there further. And there is one very easy way to define whether or not you've consented to anything. What is that, Mr. Double D?
To explicitly say, I do not consent.
Can everybody say that? I do not consent.
You know, it's ironic, but most of these cases that we read are all about establishing whether an individual is given consent when it's as easy as saying, I do not consent. None of these cases would have been difficult to resolve had those defendants in the beginning say, I do not consent.
From the very beginning. Now, some people say, I do not consent, but then they get chatty. Then they start talking. Then their actions go against their words. And guess what you just did if you get chatty or you decide you wanna talk or whatever?
You gave consent.
You just gave up your consent. You just waived your consent after you said, I do not consent. And that's confusing to the police officer and it's confusing to the courts. And so what do the courts do?
They defer to law enforcement and they say, you gave consent.
Absolutely. Now, being congenial, making a joke and laughing about it is an indicia of consent. Think about that for a second. It's really tense, you know you're being profiled, and you just make a joke and people laugh. You know, we were just talking about the court cases where that actually establishes consent. So you shouldn't laugh with them. You shouldn't treat them like your buddies. You should be kind and you should be respectful.
Professional.
Very, very professional. Very professional. But you need to say, I do not consent on multiple ways. Now, another way you can consent is by simply answering their questions. Whatever the question is. You know, they could ask, how do you like the weather? You answering their questions is, in fact, consent.
And sometimes, I actually learned this yesterday, but sometimes answering a question that you think you're required to answer is not the case, and that gives consent as well. Like confirming your address on your driver's license, for example. Something you think you would have to answer, the proper answer should be, sir, I don't answer questions.
That's right. I do not answer questions. Do you want to write that down too? Thank you. I do not answer questions. So, can you repeat after me? I do not consent. I do not answer any questions. Now, they will keep asking you questions, right? And you can just simply say, I do not answer any questions. Now, if you do not know whether or not you have to answer that question, what should you do? You ask them. You asking the question, is this a request or a demand? Is this a request or a demand is not granting consent. That's asking for clarity. And you can repeat these things as many times as you would like.
And probably will have to, because they'll attempt to continue to ask you the same questions over and over.
Exactly. Now, the question where I tripped up Double D the other day was when we were role-playing, and I just simply said, do you have any weapons on you, and what did you say?
I said no.
Did he answer the question?
Yeah,
Is he participating in the conversation? Right?
As innocuous as that seems, that's consent. What I properly should have said is I do not answer any questions.
Yes, and if there's a question you're required to answer, or the police believes you're required to answer, and you say, I do not answer any questions, they will tell you you're required to answer that question. And then what do you say, Double D?
Sir, I don't answer questions.
And if you have any question of whether or not they're required?
Is this a request or is this a demand?
It's that easy.
And if it's a demand, then you're required to answer. And if it's not, I don't answer questions, sir.
Okay. Now, if it gets to the point where it's your word against the officers, what do you think is going to happen? They're going to believe the officers. So what do you do anytime you have law enforcement? You take out your phone and you start recording. That is to protect you, and that is to protect them. And in the Ninth Circuit specifically, Fortescue Seattle was the very first case to where a circuit court said that that you had the right to film police officers doing their official duties in public. All of the odd number circuits have affirmed the right to film police officers in public doing their official duties.
I don't think it could be overemphasized how important video is. In the majority of cases that I've been involved in and I've consulted on, whether there was an explicit video was one of the most important factors, because the fact pattern can't be denied when it's on video.
Yes.
It's not conjecture anymore.
Exactly. And we ran through, there's what, about 20 factors of whether or not you can consent?
Yeah, at least 20.
Yeah, including whether or not you know your rights, the situations. They look at the totality of the circumstances. And the way to define that there is no consent, so you never get there, and you have established exactly what this is to simply follow this. I do not consent. They ask you a question. I do not answer any questions. They ask you to do something. Is this a request or is this a demand? And then fourth, which is very important to do, actually a lot, am I free to go? You can say that as many times as you like. That's number 4.
This was something interesting. What happens if you remain silent and say nothing?
That's a factor. You simply remaining silent and saying nothing can be interpreted as consent, and has been by many courts. Now, you saying the word Fifth Amendment. If you say the word Fifth Amendment, that's not remaining silent. That's establishing the Fifth Amendment, but then being silent and you're just fine. But if they ask you questions and you remain silent, the courts have interpreted that sometimes as consent, which is counterintuitive.
It surprised me you have a Fifth Amendment right to remain silent, but yeah, that surprised me as well.
Yeah.
So it's better to say, I do not consent. Sir, I do not answer questions. It's relatively simple. If you stick to this platform and you say nothing else other than what's on that board, you will not give consent.
And am I free to go? Am I free to go? Now, there's a case called Berkemer. And Berkemer establishes that if it's an ordinary or routine traffic stop, the rights in Miranda case, Arizona v. Miranda, or Miranda v. Arizona, the rights in the Miranda case do not apply. And we talked about what's an ordinary and routine traffic stop according to the United States Supreme Court at the very beginning of this. Okay. However, if it goes beyond an ordinary or routine traffic stop, then the protections in Miranda do apply, including the Fifth Amendment right to counsel. You do not have a right to have an attorney there during an ordinary or routine traffic stop. However, if they go outside of the mission of the stop, if they do anything outside of that, or the circumstances surrounding it are not ordinary or routine.
Or it changes into an investigatory stop, right?
Yes, exactly. Then you can say, I want my attorney. You can say that, and they're required to allow you to have your attorney before they continue any questioning, as long as that you're not free to go and they're asking questions, right? With some things that could happen. Oh, gang task force shows up with AR-15s and tactical vests, right? Is that an ordinary or routine traffic stop?
No.
It isn't. Isn't absolutely. Them asking about your patches. Here's a tricky one. That can be part of an ordinary routine traffic stop. Now, we don't agree with this, but under the Arizona v. Johnson, Arizona v. Johnson, under that case, for officer safety, they are allowed to inquire about any gang associations. And of course, we don't believe that motorcycle clubs are gangs. Of course, but the courts tend to say otherwise.
There is a limitation on that. They're allowed to inquire about your suspected gang membership if that's what they believe. Not only you're not required to answer that, but they are not allowed to extend the duration of the stop beyond what it would reasonably take for the traffic infraction.
Exactly. So they can inquire. Now, if you start answering questions about your patches or your association or anything, what have you just done?
Consented.
You just consented. And so we have to go back to here. I do not consent. They ask you about your patches, anything else going on, how many of you are there, whatever. I do not answer any questions. And if they tell you to do something, you simply say, is this a request or is this a demand? And if they say it's a demand, you're recording, you do it, but then you have your recording and you can come and see me or any other attorneys. Now, there's a lot to remember, right? So in Nevada, I've made this easy for you. And I've also offered to help any attorney in any other state, any of them, with the 50-state version, and they can add their own. But my office gives away these little wallets for your registration and insurance. You stick your registration in this pocket, you stick your insurance in this pocket, and if you get pulled over, before the officer gets there, you get out your driver's license, you stick that in the pocket also, and you simply show them this card. You hand this to them. Now, they may not like it, but you can say, look, I just exercised my rights. Here's the card. And they may look at it and throw it away or whatever. But you know what? You have just communicated to them. Under the Heibel case, H-I-I-B-E-L, it says that the Supreme Court, United States Supreme Court, said that the person that is suspected of doing something can communicate things in the manner in which they choose. Somebody asked me the other day, can I just talk to them in sign language even if they don't know sign language? And I guess the answer is yes, but that might not be good, right? Or Portuguese or Spanish or whatever, right? But this right here very clearly establishes, hello, officer, this is not a consensual encounter. No searches. I want my attorney. I don't answer any questions. I will not waive any of my rights.
And what's nice is once you hand this card to them, you can continually refer back to the card as your assertion of rights and not have to remember every one of those details.
Exactly. And this then becomes evidence. This exact card or this exact wallet will be evidence in your case, whether it's a civil case or a criminal case, because you just communicated to them. And if they choose to ignore it, that's at their detriment. But you have it and you did it. Now, I also put on here the 4 cases, and I want to quickly go over these because either police don't know or don't care. One of the two, right? Don't know or don't care. By the way, I've got hundreds of these right behind us on a table, and I've got more, so you can have them at any time. Or come to my office or whatever, and if you are an attorney or have an attorney out of state, I've got the printer, I've got it prepared for a generic 50-state version. You can put your attorney phone number on here or whatever. It'll be really good for accidents, or if you get in an accident, you got an attorney ready, whatever.
There's a bunch of them back here.
You attorneys, just contact me. I will give you all the information you need so you can do this yourself, and you can help people in different states. But number 1 is very, very important. It's Rodriguez v. United States. Double D knows a lot about this. I want Double D to talk about this.
Rodriguez was a case that happened in 2015. An individual was pulled over for a traffic infraction. However, the officer suspected that he was carrying drugs or that he had narcotics in his vehicle. So he extended the duration of the stop until a dog could arrive on scene. And what the Supreme Court said is that was an unconstitutional extension of the stop, that in order to be able to, for example, run a dog around a car, it has to happen within the confines or the normal time frame of issuing a normal traffic infraction, exactly what Stephen was discussing. So it means they can't do anything outside the scope of that traffic infraction if it means extending the time of that infraction. And although this case involved a dog sniffing drug dog, it can apply to any sort of investigation that's outside what they call the mission or the scope of the traffic infraction. That's essentially what Rodriguez says. And it changed the way all of these cases were interpreted, because before, for example, the Johnson case, you have an officer's safety concern, they could extend the stop as long as it was a minimal extension of the stop. This new case, Rodriguez in 2015 says they can't extend it for a second beyond what it would reasonably take to issue the infraction.
Yes, and the only exception to that is consent. Is if one of your guys decides to get chatty. If someone or just tells a joke and everybody laughs. If your body language makes you look dangerous and they need to do something additional for their safety, right? You saying silent and not saying I don't answer any questions or Fifth Amendment. You not giving them these cards. A lot of things that you would think are just normal, right? Treating them like your buddy. That can give consent for them to do all kinds of things and extend. Now, there's a case in Texas that's fantastic. Double D, do you want to talk about that?
Which one?
The tattoo case.
Oh, yeah. There was an individual who was actually traveling to school. He was a member of a motorcycle club in Austin, Texas. He is pulled over for what they claim is a signal infraction. Immediately upon being approached by law enforcement, they say, we pulled you over for a traffic infraction for a failure to signal. We're not going to issue you an infraction for that or a citation, but we are going to take a picture of every tattoo you have on your body. We'll either take you to jail or you'll do it on the side of the road. He quickly pulled out his camera, videotaped the entire incident, and the first thing that he said is, I do not consent to you searching me. I object to this. They searched him on the side of the road, they disrobed him, took his shirt off, took pictures of every tattoo he had on his body, and ultimately that video and the fact that he said he did not consent ultimately ended up in a settlement for that individual. Not only was there a legal judgment and the Austin Police Department, those officers were reprimanded, but the individual also got a monetary settlement of an undisclosed amount. But what he simply did is videotape the incident, and he remembered to say, I do not consent.
And the only reason that's settled is because he said, I do not consent, and he videotaped it. Otherwise, they're going to fight you in court. They're going to take the totality of the circumstances, and they might not even be honest. There's times when officers don't tell the truth because they're covering their rear end. And unfortunately, that happens. So you videotaping it and you saying the words, I do not consent, I do not answer any questions, is there this a request or demand, and am I free to leave? May I go?
Yeah, and what's interesting about that particular case is he's the only one there. He's being searched, but he's recording it with his other hand the entire time. He's not obstructing what the officers want to do, but they could not stop him from videotaping the entire incident with his other hand. So. Yeah.
Now, the second one that I have on this little wallet is the Flatter case, United States v. Flatter. That's the one to where the case to where it says that in order for them to pat you down or frisk you, they must have reasonable suspicion that you are both armed and dangerous. United States Supreme Court case. That is good through the entire United States. Nevada, I was part of this. I had a client. We were able to win a federal case that actually said that wearing a Mongol patch is not reasonable suspicion that you're armed and dangerous. We are the only state in Nevada that has that, right? However, there's a blueprint. If you have that problem and you're an attorney fighting that issue, contact me. I'll give you the briefs. I'll give you what was successful. Let's get this established in your state as well, so that it can be very specific, and you can tell a law enforcement officer, no, just because I associate with these wonderful people does not mean that you can say that I'm armed and dangerous just because you're profiling me. That's important. Now, number 3, is there anything you want to add on to that? Awesome, all right. Number 3, in Nevada, there's a duty to identify statute. You need to know the duty to identify statute in your own state. You need to know that, because that's important. Because otherwise, you might have to guess if they tell you you have to identify yourself and you don't know your rights. Now in Nevada, they can only identify you when there's reasonable suspicion that you have done something wrong, and then you only have to state your legal name and nothing else. Nothing else.
That's if you're the passenger, not the driver.
Well,
right?
Well, just a second. The only 2 exceptions to that are if you're the driver or if you have a CCW and you are carrying concealed. If that happens, you must give them your CCW and give them your driver's license or your identification. You have to do that. And if you're a driver, yes, you have to give them your identification. That is Nevada. Every state is different. You need to know that. But in Nevada especially, not the passenger. Not the passenger at all. And in fact, in most states, passengers do not have to identify themselves. But in some states, they will threaten you. They will literally threaten you and say that if you voluntarily act upon their threat, it's legal, which it's not. That's called coercion, and that's against the law. But still, police officers don't always follow the law, and they don't always tell the truth. And so it's very important that you know your duty to identify statute in your particular state. Anything you want to add to that?
No, I think that every state is different, and so you have to research your own revised code. Like, for example, in Washington, you have to identify when you have a concealed weapon, and you have to identify as the driver but not a passenger. But yeah, I think that's probably generally true in most states, okay. But some states are different.
Awesome. And then the 4th thing that I have on here is the Berkemer case that I talked about earlier, right? When it is an ordinary, and this is good in all 50 states, when it is an ordinary or routine traffic stop, the protections of Miranda do not apply. However, if it extends out beyond that, then you can ask for an attorney under the 5th Amendment. And the Miranda does, in fact, apply very much, very much. So if everything that I talked about in the very beginning, that we talked about in the very beginning happens, they just come, you give them your license, registration, insurance, they take it, they do a wants and warrants check on the driver, they maybe even do some things for their own safety, they can have you get out of the car. If there's reasonable suspicion that you're both armed and dangerous, by the way, if you have a CCW, that is reasonable suspicion that you are armed.
But not necessarily dangerous.
But not necessarily dangerous. So if you have a CCW and you're being a jerk, they get to frisk you. So don't be a jerk, right? But still, don't be super friendly either. Otherwise, they might think you're consenting to things, right? So that's if they go within that scope, Miranda doesn't apply. And then they can give you your ticket and you can go about your way. However, if they ask you about your patch, if they ask you about your associations, if Gang Task Force shows up in tactical gear with AR-15s, if anything happens to expand the mission of the traffic stop, then Miranda applies and you are within your rights to say, I want my attorney. Oh, by the way, you gave him this, so here's his cell phone. I'd like to call him, please. Right? They walk away with your ID, right? You stop recording, you call me, tell me where you're at, right? Text to me where you're at, I will show up. I've shown up 5 in the morning, 2 in the morning. I care that much about you guys. You know, a friend of mine is right there. I showed up at his house really, really quick. I do that, and I will do that for you if it's at all physically possible, right? But then hang up after you've texted me where you are, hang up and start recording again so that you can have that evidence.
You know, what I think a lot of this comes down to everybody's heard the cliche, we're our own worst enemy. And I think that it's particularly true with traffic stops, because most of the things that go sideways or end up having a bad result is because not being prepared to handle the situation correctly. It's very simple. I do not consent. I do not answer any questions. Is this a request or a demand? And am I free to go? If you stick to those 4 principles, then you will have a lot less likely of a chance of being your own worst enemy.
Yeah, and if you get these cards and put your registration and insurance, by the way, it's an arrestable offense in Nevada if you don't have your registration or insurance on you, or your driver's license, so don't write dirty either. But if you have this is very easy. In fact, take 2, so that when the officer takes one, you still have one. I can print as many of these as you guys want, and I'm glad to do it. I've even printed stuff on t-shirts and given it to people, right? And people have actually worn those, and police officers have backed off because they're wearing a t-shirt. Because they're wearing a t-shirt, and so that's important. And I've got the 50 state t-shirts. I mean, we can sell those to you. My daughter's selling them. So in these things they can be so simple if you keep them simple. But if you don't do what you're supposed to do, then all of a sudden it becomes very, very complicated. And if you get mouthy, if you're disrespectful to that officer, if you crack jokes or do anything else that people kind of like to do to maybe troll an officer, because you have a First Amendment right. You have a First Amendment right to say those things, but if you exercise that First Amendment right, you are waiving your Fourth Amendment right. Think about that for a second, because you are now consenting to furthering the stop. And I joke around a lot about singing to cops, and I do it on video and I post them, and I think it's hilarious. I consciously waive my Fourth Amendment right to extend the stop so that I can sing to those police officers, because I think it's funny and I want to do that. But you know what? If I'm in a group, I'm never going to do that.
I don't sing to them because I want to get the fuck out of there.
Exactly. If you're in a group, just know that if you are waiving consent, you're doing it for everybody. So know that. Just know that. Don't be mouthy. Don't pop off. Get it all done, get it recorded, and get the hell out of there.
I think that was pretty complete.
All right, cool. Any questions? Okay. Thank you so much. We appreciate it.
Appreciate it.